Good evening, ladies and gentlemen. Welcome to tonight's Zoning Board of Appeals hearing. Before we begin, let me introduce some members of town government that act as advisors to this board. To my left is Simone Freeman, counsel to the board. To her left is Blaise Donadio, senior planner in the planning department. To his left is Matt Collado, planner in the planning department. And to his left is, yes, I got it right. Oh, senior planner? I'm sorry, Matt, I did not get that right. To his left is Sabrina Butita. She's an environmental analyst with the Department of Environment and Waterways. You're here this evening seeking relief from the town zoning ordinance. New York State statute requires that any town that adopts zoning must also have a Board of Appeals to act as a relief valve so that persons can seek relief without the expense of legal proceedings. The most common kinds of applications before this board are area variances. Area variances deal with dimensions of lot area, frontage, height, setbacks, and parking reductions. New York State statute mandates that the board must consider the following 5 criteria when evaluating area variances. When you come up to the podium, please do your best to address these 5 criteria. 1, whether an undesirable change will be produced in the character of the neighborhood or a detriment to nearby properties will be created. 2, whether the applicant has other feasible alternatives. 3, whether the variance is substantial. 4, whether an adverse impact on the environment will be created. And 5, whether the alleged difficulty is self-created. I believe they have them listed up there on the podium. Is that sheet there? So if you don't have to remember them. The board also has the authority to grant special exceptions, also known as a special use permit or a conditional use permit. This is a use that is permitted by zoning, but under specific conditions designed to ensure compatibility with the surrounding area and the overall zoning plan. If all of the general and specific requirements are met, the board must approve the application. If they are not, the board must deny it, unless they request variances. At that point, the 5 considerations and balancing test shall be applied. What is the balancing test? Statute requires that the board balance the interests of the applicant and those of the neighborhood or community. The board shall grant the minimum variance it deems necessary and adequate, while at the same time preserving and protecting the character of the neighborhood and the health, safety, and welfare of the community. The board has the power to impose reasonable conditions that relate to the variances. Regarding procedures, cases will be called in the order that they were advertised. When your case is called, please come forward. Submit your affidavits and mailing receipts to Mr. Donadio. I believe everyone's already done that?
I believe so.
Okay. If you haven't, do it when you come up. And the applicant will be given the opportunity to explain to the board why the variance is needed. Again, please address the 5 criteria. After the applicant is done speaking, all interested parties will be given one opportunity and only one opportunity to be heard. Please organize your thoughts and keep your remarks factual, related to the case, as well as the variances being sought. Then we'll ask the applicant to come back to the podium to address any concerns. The board will then close the case and reserve decision. After all hearings are closed, the board will review cases and decide some of them, and others will be reviewed at a later date. There are 3 ways to find out about your case. The first is you can wait until after the public hearing, but there's no guarantee that we're going to act on that case tonight. The second way is to check the website after 11 a.m. tomorrow. Third way is applicants can wait and be notified by mail. After the case is closed, no additional testimony can be submitted. I believe we have 2 adjournments this evening. First one is case 19332, Jacob Levy and Carolyn Colella. Is anyone here for that case? That case is going to be heard on July 15th now. And the second adjournment is case 19345, Good Meats LLC. Anyone here for that case? That case is going to be heard on August 12th. There was another one that you thought might be adjourned tonight? Do we want to just wait and call it later?
Yeah, that's fine.
All right. Blaise, it's all yours.
All right, thank you, Mr. Chairman. The first case on the agenda is case number 19299, Lauren Guerin, 5 Deborah Drive, Wisconsin. The location of the property is the east side of Deborah Drive, 180 feet north of Bonark Lane. The property is zoned R15. The applicant is requesting a special exception to permit temporary living quarters for a child, a variance of a special exception standard to increase the floor area from 602 square feet to 865 square feet.
Good evening.
Good evening. We,
Just name and address for the
Oh.
record, sorry.
sorry, Lauren Guerin, 5 Deborah Drive, Nesconset.
And we have the spelling from the application. Okay, thank you.
You have it, okay. I was seeking a special exception for my son, who's turning 30 in July. He requires 24/7 care, so we were looking for a space where he could have some privacy, but yet, in case of an emergency, I was, close by, because 24/7 care is kind of hard to find. I don't think it would be a hardship on the neighbors. The property was actually zoned before for housing, I believe it was their parents, elderly parents. And I guess that's really it.
This is a special exception, and the planning department does prepare a planning advisory report, which they did. Blaise, you want to?
Yep, so we reviewed the application. There is a variance request to increase the size of the floor area. Many applicants in the past have made the same or similar request, and the board has previously granted increases to accommodate the proper size space that's needed for the person occupying it. So we recommended approval based on what we saw.
Okay. Anyone on the board have any questions?
Good.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved. Second.
Motion and a second. All in favor?
Aye.
Thank you. We did that already. Yeah, nice and easy.
Well, good.
All good?
Okay. The next case on the agenda is case number 19335, Pasquale and Megan Iannucci, 8 Rita Crescent in Comac. The location of the property is the south side of Rita Crescent, 273 feet north of Donna Lane. The property is zoned R10. The applicant is requesting variances to increase the maximum height of a retaining wall from 4 to 6 feet for a proposed concrete retaining wall, and to permit a fence greater than 4 feet in the required front yard. To reduce the minimum setback of a 6-foot retaining wall from the property line from 6 feet to 0. To reduce the minimum setback of a 4-foot fence to a 6-foot retaining wall from 6 feet to 0. To increase the height of a 4-foot fence on top of a 6-foot retaining wall from 4 feet to 10 feet.
Good evening.
Good evening. Pasquale Iannucci, 8 Rita Crescent, Comac, 11725. We respectfully request relief from the zoning ordinance to permit the construction of a 6-foot retaining wall with a 4-foot fence above it, located in the required front and side yard with reduced setbacks to the property line and between the wall and fence. Strict compliance with the current ordinance limiting wall and fence height and requiring minimum setbacks will result in practical difficulty due to the unique grade and elevation changes. Excuse me. Elevation changes of the property which require a higher retaining wall and fence configurations for safety, erosion control, and privacy. The practical characteristics of the lot make it impractical to meet the standard height and setback requirements without significantly compromising the functional use of the yard and structural integrity of the site. These requested variances are the minimum necessary to provide a safe, code-compliant, and visually consistent solution. Furthermore, granting this relief will not negatively impact the character of the neighborhood and impair the intent of the zoning ordinance. It was a wood retaining wall. It was damaged in a flood, and we can't replace it with wood, and we just want to keep where it is, just it would be concrete instead.
Okay.
It's the long and the short of it.
Anyone on the board have any questions? No? Okay. Planning?
No, thank you.
Sabrina?
No, thank you.
Would anyone in the audience like to be heard on this application? Okay, you want to come, you can come up. Mr. Iannucci, you can come back up when he's done.
Thank you.
I'm the design engineer
Okay,
for the drawings that you're holding.
Okay.
Just wanted to point out. Anthony Marmo. M-A-R-M-O. I'm the design engineer. If you look at page 3, it gives a nice visual of what the wall will look like. And then, of course, there's going to be vegetation in front of the wall. It's much of an improvement to what's there now. That's all I want to say.
thank you. Anyone else like to be heard on this application? Mr. Iannucci, did you want to come back up, or?
Thank you.
Okay, thank you. I guess you don't want to argue with that?
No, I do not.
Okay, thank you.
Thank you.
Need a motion to close?
So moved.
Second?
Motion and a second, all in favor?
Aye.
All right, case closed, thank you.
Thank you. Good evening.
You too.
The next case on the agenda is case number 19336, Lewis A. 51 Brookside Drive, Smithtown. The location side of Brookside Drive, 46 feet south of Albatross Lane. The property is zoned R21. The applicant is requesting variances to increase the maximum permitted paving in the front yard from 25% to 30% for a proposed driveway expansion, to increase the permitted width of a driveway curb cut from 20 feet to 30 feet.
Good evening.
Good evening. Louis Anthony Farisi, 51 Brookside Drive, Smithtown, New York.
You? Want to tell us why you're here?
I'd like to expand the driveway to cover both garage doors and to improve the site itself because the asphalt is deteriorating and it ruins the aesthetics of the neighborhood.
Okay. Anyone on the board have any questions? Planning.
Just one comment for the board. Under Chapter 322, Section 64B, which covers curb cuts, driveways, sidewalks, and things of that nature, there are minimum and maximum requirements for the width of curb cuts. The minimum width requirement for a residential curb cut is 10 feet. It doesn't specifically call out a maximum width. However, the Highway Department would have to issue a curb cut permit in order for the existing curb cut to be removed and expanded, and they would have to review the application prior to issuing a permit.
So do we need to get a recommendation from them first, or can we act on it and then they get a permit? Do we decide on it first, or do we get a recommendation from Highway?
Please seek the board.
Yep, go ahead.
I went to the Highway Department.
Hold on one second, please.
I've gone to the Highway Department. I seek their advice. They were the ones who told me to first approach the building department with my plans, that they would automatically deny it, send me over to planning, apply for the variance. Once the variance is given to me, then I go back to highways, and then they will issue me the permit and give me all the specifications that they require to widen the driveway, as far as the curb cut, as far as the required thickness of the concrete, the separation between the curb and the apron.
The question I would have is that this board typically deals with paving percentages. We don't, in my time, I don't recall ever having increased the size of a curb cut. I don't know that I would feel comfortable saying go to this width without consulting the highway department. So, you know, is it possible that you could deal with less than 30 feet? Because obviously cars are only 8 to 9 feet wide.
It's a two-car garage, okay? And for the lack of a better word, the driveway looks like a pork chop. And if there's a car in the driveway, I have to drive over the curb to get into the the garage.
Right, but would you be comfortable if we consulted with the highway department and found out what the minimum width for 2 cars to go in and out of a driveway? Because 30 seems like a lot.
I would recommend maybe he can file his permit application with them, and then we can coordinate with them before we issue, so that we make sure.
Right, we can deal with the percentage of paving, it's just the curb cut I'm not.
Yeah, so that's what I'm saying,
Comfortable
maybe, now that you've come to us, I think the recommendation could be to go back to highways, explain that you've come to us and you want to file your permit your highway permit application with them for the curb cut, and then we can coordinate to make sure, because if we approve something, like you said, I don't want it to be that it's not going to be sufficient for them.
Not that it's
and
not
or us.
sufficient, or if it's too much, that, you know, now
Exactly.
30 feet is, you know, that's basically the width of 3 cars, and now it's just curb cut after curb cut, which I know highway is very reluctant to grant
Yes.
additional curb cuts.
They are.
So, all right, I think we know what to do.
Okay, send it?
Well, we just gotta see if anyone else has any comments, so. Sabrina, did you have anything? Anyone in the audience have any comments or concerns on this application? There being none, I'll entertain a motion to close.
So moved.
Motion and a second. We'll close it and then we'll talk to highway.
Okay, thank you.
And if we need you to go back to highways for anything, we can reach out, we'll reach out to you and let you know as well. Okay?
Thank you.
Thank you.
Approve just the,
I think so. Yeah, I think so.
Yeah, I think this is the one that's going to get adjourned. The next case on the agenda is case number 19337, Gary Shank, 150 Lillian Road, Nesconset. The location of the property is the south side of Lillian Road, 503 feet east of Gibbs Pond Road. The property is owned R10. The applicant is requesting a variance to increase the maximum permitted paved surface in the front yard from 25% to 38% for an existing asphalt driveway.
Is anyone here for case 19337? That was the case we thought might adjourn.
Yeah.
All right, so we're gonna give them August 12th. Next, let's put it all away. That was easy.
All right. The next case on the agenda, case number 19338, Stephen and Brittany LaRosa, 37 Country Lane Drive, Kings Park. The location of the property is the north side of Country Lane Drive, 1,323 feet west of Fort Salonga Road. The property is owned R10. The applicant is requesting variances to reduce the minimum setback of a 6-foot fence from a 2-foot retaining wall from 2 feet to 0, to increase the height of a 6-foot fence on top of a 2-foot retaining wall from 6 feet to 8 feet for an existing 6-foot vinyl fence on top of a 2-foot existing retaining wall.
Good evening.
Hi, I'm Stephen LaRosa. I live at 37 Country Lane Drive, Kings Park. And this is Kelly, my expediter, and she's going to help me out with this. Yeah.
Good evening.
Just name and address
Yep.
and spell your last name.
Kelly Bennett, last name is Bennett. Address is 1257 Udall Road, Bayshore, New York, 11706. Good evening. So I'm here tonight on behalf of Mr. and Mrs. LaRosa, as well as the fence company that did do this installation, which was Superior Fence. It's a little bit of an unfortunate situation all around. There was an existing stockade fence, so Stephen and his wife were looking to replace that with a nice new PVC fence. The 2-foot retaining wall was never noted on the updated survey when it was done specifically for the fence. a permit was applied for and issued. So this was actually picked up in a building inspection. We are non-conforming in terms of our retaining walls and pavers. So we're just seeking, relief here tonight from the board on the retaining wall and, to reduce the minimum setback from 2 foot to 0 foot, from a fence to a retaining wall, and increase the height from 6 to 8 feet. So as you could see in this photograph, it's probably about, 10 foot, would you say?
That's the wrong photo.
Oh, okay.
That's the wrong photo. It's the other side of the yard that has the timber.
So if you, but that was the existing retaining wall that we're on top of, unless you have a different,
That one, and it's the retaining wall in between me and my neighbor. That's what's missing it.
oh, okay. So actually, Stephen has corrected me, it's the, which would be the, east side, right?
Yes, yeah.
The east side of the house. So that whole section, I actually highlighted there, so I even missed that. So the 2-foot retaining wall is on that whole east side of the property. So it was really a change of material to the existing non-conforming fence.
Do we have any pictures of that?
Yeah, I
other
actually
one?
have a whole bunch,
Okay.
and that does show that. Let me- Okay.
It's over here.
On that side, okay. Yeah. Yeah. So really, you can only see it from the other, the retaining wall.
What's that?
Yeah. Okay, for the inspector? Okay, interesting.
This is it here. The retaining wall's on the outside of it.
Yeah, so this would be a better photo, maybe I'll find it, could show you this photo, so if you could see.
Why don't you grab the mic
Okay,
so that we can get it on the record?
show that to me.
Here's the wall on the outside. Yeah, correct. Okay. And according to the survey, it looks like that wall is about 1'4" off of the property line?
Exactly,
Okay. Want to hand that back? You
Yeah,
can
they-
take this back.
absolutely. Yes, so
That's-
any questions, we'd be more than happy to
I'll find out.
answer.
Anyone on the board have any questions? No? Guys? Planning?
So just a question, so we can clarify. You said it was the east side of the property?
Yes.
That corner, if you look at the north arrow, is the east side of the property.
It's,
So it has to be the west side of the
it's,
property.
yeah, I'm so sorry, because, so with his north arrow, so it is the west side. It is.
And we do not have any photos of that?
We do.
Well,
We
they just
do?
showed us the one and the ones that,
So you can't really see the retaining wall from, our property side. It's really from the opposite side where you could kind of see the retaining wall come up, in between the old chain link fence and the fence that was installed for Stephen.
So that's the wall right there.
Yep.
And it looks like it goes underneath the fence, right there,
They're saying this is the west side.
right?
I think it's the right.
Yeah.
You're
I mean,
saying-
quite honestly, the fence on the east side looks like it's on a much larger retaining wall than the fence on the west.
Yes.
So, I'm not really sure which one is correct.
Yeah, and again, like I wanted the board to understand, the intention was to, do the right thing, get an updated survey, go to building, a permit was issued, so we're more than happy to, answer anything or help the confusing situation.
Do you feel like we should get clarification from building?
I would just like to know what the height of the wall on the west side is, because looking at it, it,
Looks like they're both.
yeah, so I don't want them to get the wrong variance, because if they get the variance for the wrong side, building is gonna send them back. So,
So
yeah.
we can kick this back to the building department and have them clarify. The walls are up and the fences are up. It's not like you're waiting to put them up. You just,
Yeah, you know, he just wanted to be in compliance and kind of put this behind him. Was
Yeah.
really all.
we just need clarification, because if we approve that one fence and it turns out this other one is out of compliance also, you're gonna be back anyway. So-
Okay.
And that would involve additional fees.
Well, we would
This way, we
greatly
could kick it
appreciate
back to
that.
building, get clarification, and just put you on. Can you come, we're kind of packed the next meeting. It would be the August 12th meeting.
I could come back the 12th. Would Stephen have to?
If he gives you power of attorney, you can come by yourself.
Great.
All right, we could do that at this
Yeah.
point. We have enough time to
Just
do
make
the
sure you get
power- Okay,
just check with the planning department to make sure you get the right
Okay.
power of attorney.
all right.
Okay,
I'm
so we're
sorry
gonna
for
put
the
you-
confusion.
It's okay. We'll put you on for August 12th.
Okay, beautiful. We shall see you then.
Thank you.
want these photos back?
No, they're for you guys.
They'll be in the folder.
Beautiful.
Yeah, the other side is more.
It was lower, yeah, it was lower, you know, so we're waiting for, okay. Cicilline? Nope, Ralph is here. So I just gotta write this down. Building Ray, which side?
Thanks, Bill.
Okay. All righty. The next case on the agenda, case number 19339, Danielle Cicilline, 10 Sherwood Drive, St. James. The location of the property, the south side of Sherwood Drive, 256 feet west of Lake Avenue. The property is owned R21. The applicant is requesting variances to reduce the minimum front yard setback from 50 feet to 39 feet for a proposed 155 square foot front addition, a proposed 270 square foot front porch, a proposed 375 square foot second story addition over a garage, and a proposed 316 square foot second story addition. Reduce the minimum distance from any lot line from 8 feet to 2 feet for a proposed 408 square foot shed and a proposed 400 square foot pavilion.
Good evening.
Hi, I'm Danielle Cicciolini. I'm located at 10 Sherwood Drive, St. James, New York, 11780, and I'm going to have my architect Ralph speak on my behalf.
Thank you.
Hi, I'm Ralph Michelle. My office is 255 West Main Street, Smithtown, New York, 11787.
All right, thank you.
So we do have one change to the plans. We were told that we would need to go to Board of Health. So to circumvent that, we changed the second floor bedroom count. So there's currently 2 bedrooms on the second floor. There's an office on the first floor that could be considered a bedroom. It's quite tiny, but it could be considered a bedroom. So we removed the third bedroom that we're proposing on the second floor and left it as the 2 bedrooms. It's a cape, so you have knee walls front and back, well, actually on the front. So we're just gonna square off the existing second floor and then add attic space over the garage. So the top left-hand corner, that circle is only attic space accessible from the garage. Go over to there you go. So that's above the existing garage, right there. And you can see in the middle part that's not in the circle, there's 2 bedrooms front and back. So the wall that's going in between, I spoke with Josephine this afternoon. We're gonna remove that wall and just make that all one large bedroom for their daughter. So I have, not to scale, but I brought plans for the second floor for you guys to look at. Josephine thought it was a fine alternative because we'll get rid of the bedroom. So as you're looking at the plan, you'll see that when you get to the top of the stairs, you just have the existing master bedroom on the right. We're expanding over the front of the house for the walk-in closet on the right side there. On the left side, you go into the existing door where there is a bedroom, and the knee wall area towards the front, we're just going to tilt the wall straight up, get rid of the knee wall, give it more space, more habitable space on the existing framing below. So everything on the second floor is contained within the footprint of the first floor. And like I said, we just left the two walk-in closets for their daughter. I'm sure she'll use them. But like I said, the access to the garage is only, the second floor of the garage is really just for storage. There's a pull-down stair, and you can't get to it from the rest of the second floor. Does that clear up anything there? Okay. For the first floor in the house, we're just expanding the living room in the front, which is what's causing the front yard setback issue. So it's an existing living room or family room now. We're just giving them a little more elbow room in the front of the house. That's the only change to the first floor. As for the backyard, they already have an existing pool in the backyard. So we're proposing a pergola. When you're looking into the backyard from the house, on the right side, what you're seeing up on the screen now is the 20 by 20 pergola, open on all four sides. They have a very deep property, so it's pretty well set back. You're not really going to see this from the street. The neighbors have a pretty deep property. I mean, it's in the neighbor's way deep backyard. So they're proposing to have that on the one side of the pool, and then the shed, it's a larger shed, on the other side to go up against where their pool filters are. All their outdoor equipment could get thrown into that large shed, and keep it keep it indoors during the winter.
What's the height of that pavilion?
$14.6.
6 inches. And I notice I don't see the pavilion on the survey. Do we have any of these surveys that show where the pavilion's going?
It's on my site plan. It's highlighted on the bottom of there, on the bottom left, but it's on my sheet ASP1. It's called out proposed 2020 gazebo, 400 square feet, right there. But that's been highlighted on, I guess, taken off of my site plan.
Okay, and that's a gable roof.
Correct.
Now, which way is the gable roof? Is the low side against the property line?
So the gable is going to go, so you're going to see the high side against the property. So when you're looking at it from the backyard, you'll see the the roof shed up on you, and the decorative piece is facing the pool. So what you see in the bottom right-hand corner of that screen is going to be, if you're in the pool looking at the pergola, that's what you're going to see. So from the neighbor's side, you'll see the opposite side of that.
Is it possible to either switch it so that the gable faces the other way, or if you turn it into a hip, so that you don't have that 15-foot high wall right against the property line?
You guys-
I mean, it's blocked by trees right now.
Yeah.
You wouldn't even really see it because our neighbor has very, very high trees that go above that.
Yeah, there you go. See those, so where that black line is, that's higher than the height of the gable.
They're
I-
very, very high, and there's multiple.
Yeah, but when we grant this, it's forever,
Right.
and the trees might not be forever, and it would be right up against it. I mean, for me, I'm not a big fan of giving you a relief to the property line when it's something that's that high, when you can actually mitigate it.
Well, it's designed so when you're in the pool, you're seeing the view, and again, that's the back side of that person's property, and I know the trees might not be there. They're
Well, I'm
highly
just trying
unlikely-
to, I'm just one person on the board, so I'm just trying to give you a little bit of,
It's highly unlikely that the trees, even if they were to go away, would probably be put back, but the person's house is in line with their house, which is 100 and... property line is 225 feet, 220 feet, 205 feet deep, so the house to their neighbors is 100 and something feet away from this,
Okay.
if you can see where their house is. I mean, and then they do have, what's in their backyard? In the back.
I think they have similar layout where they have a pool back there, and they have a area that they also hang out underneath.
Okay.
So they have a, I don't know what size their pergola is in the backyard, but it's kind of,
Yeah, it looks like it's a hip. Okay. Thank you. Anyone on the board have any other questions? Planning?
No, thank you.
Sabrina?
Mr. Chairman, our original comment was regarding the health department because you were at the time adding a bedroom, but now that they have changed the layout, it appears they don't need health department, but we still don't have a secra. So until the next meeting, we can have that ready.
Are you familiar with Secra?
what's that?
Are you familiar with Secra?
I've done just the shorty AFs, I don't have,
We don't have, you don't need, we need a recommendation. We don't have it tonight, so we can't act on this until next meeting.
but you guys do the CEQA, or?
Yeah.
Okay,
Yeah. Okay.
all right, thank you.
We'll see if anyone has any questions. Anyone in the audience like to be heard on this application? Being none, I'll entertain a motion to close the hearing.
So moved.
Motion and a second, all in favor?
Aye.
All right, case closed. Thank you.
The next case on the agenda is case number 19342, Michael and Laura Kern, 30 Witchard Boulevard, Comac. The location of the property is the southwest corner of Witchard Boulevard and Roosevelt Avenue. The property is owned R21CL. The applicant is requesting variances to reduce the minimum front yard setback from 45 feet to 35 feet, to reduce the minimum side yard setback from 16 feet to 14 feet, for proposed 735-square-foot garage addition, to permit environmentally sensitive lands to be altered for slopes greater than 15%, to permit construction within 10 feet of any slope greater than 25% for the proposed 735-square-foot garage addition and a 5-foot-high retaining wall, to reduce the minimum distance from any lot line from 8 feet to 0 for an existing 122-square-foot shed.
How you doing? Michael Kern, 30 Witchard or Wishard Boulevard, depending on which pronunciation you subscribe to. I don't know which one is right, so quite honestly, if one of you could tell me, I would appreciate it. So I'm looking to build an addition onto my home. I have an 80-year-old mother with Parkinson's disease. I'm looking to create first-floor living for her in my existing garage and add a garage next to that to fulfill my promise to my mother that I would not let her go to a home and that I would take care of her as she aged. Unfortunately, the time has come to fulfill that promise, and so this work has started, or at least is there to do that for my mom. I don't think that there's going to be any negative impacts to the existing conditions around. I have greenbelt, very limited neighbors around my area, and there's no other option that I have based on the way that my house is positioned on my land. If you look at the map or the topography of my land, it's a large plot, but there's lots of hills. And the way the land is positioned, there's no other place or way to put an extension on my house to accomplish that goal. And I have my architect, Charles, here as well, if there are any questions.
We'll find out. Anyone on the board have any questions? I believe there was a PAR for this one. Did we, is this a special exception, or no? There
No.
were- Oh, that's right, there's a door.
Yeah.
Okay. Go ahead.
I just wanted to add one comment. Charles Kuhn, architect, North,
Just spell your last name, too.
yes, Kuhn, Kuehn, office in Northport, New York. I see you highlighted the retaining wall. We are proposing a retaining wall. However, I did redesign it, so the wall is under 4 feet in height, so it would not require any special exception. Okay?
Anyone on the board have any questions? Planning.
Thank you.
Sabrina?
The current application to enlarge the existing family dwelling requires approval from the Department of Health. We need this information in order to complete our environmental review. We have notified the applicant. I did speak with Mr. Kern last week. So therefore, no decision will be made until we have that information.
Add something quickly on that point or a request for the board, and I appreciate it. Yes, Sabrina and I spoke on Friday. There's a home theater design in the plans that's being counted as a bedroom. The intention has been and continues to be not to use that as a bedroom. There's tiered seating in there. I have correspondence with a local electronics shop to plan out the home theater, speakers, et cetera. That's never been the intention of the plan. It's no more a bedroom than my living room could be or my dining room could be with a portable bed. So I wanted to see if there's any way to get an exception to that possible
Well, I think
ruling.
He just needs to get something from the health department.
Yes,
Yeah.
well, according to memorandum number 19, they view media rooms as potential bedrooms, and that's what it falls under. So I have to refer you to them, and maybe they'll tell you that it's sufficient, but
So that's as you know, that's a $5,000 process
Oh.
to get
We don't-
approval from.
We can't circumvent them.
So, okay, so that's the only option. What if we, if you zoom in on the second floor, up by the staircase, bedroom number 3, that's a room that I currently work from home. I use as an office.
an office is considered a bedroom in the eyes of,
Yeah, appreciate
yeah.
that. If I remove the wall from that
Okay.
office and no longer use it as a closed-in room, does that solve for the problem? I will sacrifice my space to not have to potentially spend $40,000 in additional efforts with the health department to do this.
You better check with your mom and make sure this is okay.
She's not able to get up to the second floor, unfortunately, so I think she'll be fine. Although
I
she does
believe
have an
that
opinion.
If he calls that hallway, that's,
potentially, I'd have to review with the head of my department, but
so
Okay.
we can't accept that unless if we close the hearing.
I'd have to see the revised plans documenting that.
So do we keep it open? So we'll keep it open.
Sure.
Submit your plans, we'll close it at the next meeting if Sabrina's okay.
That's in July, right?
Correct, July
Okay,
15th.
I appreciate it. Thank you.
Okay, thank
You're
you.
welcome.
We just gotta see if anyone has any questions. Is that it, Sabrina? Anyone in the audience have any questions or concerns on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Motion in the second. All in favor?
Aye.
Case closed. Oh, I'm sorry. We don't want to close it. We're adjourning it. Never mind. July 15th. So take back your motion.
The next case on the agenda is case number 19343, Anthony Robitaille, 1 Seaver Court, Smithtown. The location of the property is the southeast corner of Seaver Court and Seaver Lane. The property is owned R10. The applicant is requesting a variance to reduce the setback from lot line on Seaver Lane from 10 feet to 0 for a proposed 6-foot PVC fence on a corner lot.
Good evening.
Good evening, Anthony Robitaille, 1 Seaver Court, Smithtown, New York, 11787. We would like to request for an exception for a PVC 6-foot fence around our backyard, as this is for providing safety for our 2 small children. We're on a corner lot in a cul-de-sac, and we want to be consistent with our neighbor's fence, which is also 6-foot PVC from the sidewalk.
Okay. So I went by and looked at it. You're basically going to tie your fence in exactly where your neighbor's fence is and bring it straight to the corner of your house and then return it?
Yes.
Anyone on the board have any questions? No? Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved. Second.
Motion is second. All in favor?
Aye.
Case is closed. Thank you.
Thank you.
The next case on the agenda is case number 19344, Anthony Monterosso, 14 Grove Road, Kings Park. The location of the property is the west side of Grove Road, 240 feet south of Washington Drive. The property is zoned R10. The applicant is requesting a variance to reduce the minimum rear yard setback from 35 feet to 0 for an existing 734 square foot rear deck.
Good evening.
Yeah, my name is Anthony Monterosso. Everybody knows me as Tony. But anyway, I live at 14 Grove Road, Kings Park, New York, 11754. I built the deck 50 years ago. I've refinished the top again. I put new wood on the top. Everything was brand new. And I've had it, this one section is 14 feet wide, and it's 20 feet long, and it's just about a foot away from my neighbor's fence. And his fence is like 6 feet, so he don't see it. But I don't know what you want me to do. You want me to cut part of the deck off? I can do that, but everything is built to code because my neighbor, his son, his future son-in-law is Mark Reith, who does a lot of building around this area. He said to me, Tony, you want to build a deck? I'll help you build it. And if I built it myself, it wouldn't have been right. But with him, he built it the way it's supposed to be. He put 2 feet concrete things down, 2 4x4s together to hold up everything. I must have 12 of them for that one section. And I don't know what else I want to tell you. That's it. I'm just hoping that you approve it.
Okay, thank you.
I don't have anybody here that would say anything. So,
Anyone on the board like to have any have questions or concerns? Planning?
No, thank you.
Sabrina? Anyone in the audience want to be heard on this one? There being none, I'll entertain a motion to close the hearing.
so moved.
Second.
Motion and a second. All in favor?
Aye.
Case closed. Thank you.
Thank you.
Here, you want to see it? Sorry, they gave me one. I'm running on fumes here.
All right. The next case on the agenda is case number 19346, Caree Larson, 12 Milemore Drive, Fort Salonga. The location of the property is the west side of Milemore Drive, 1,273 feet west of Bread and Cheese Hollow Road. The property is zoned R43. The applicant is requesting variances to permit environmentally sensitive lands to be altered for slopes greater than 15%, to permit construction within 10 feet of any slope greater than 25% for a proposed 1,050 square foot detached garage, to increase the maximum height of an accessory structure from 15 feet to 24 feet, to increase the square footage of a detached garage from 750 square feet to 1,050 square feet.
Sure? Good evening.
Good evening. I'm Carrie Larson, 12 Milemore Drive, Fort Salonga. And I have Todd here to present just exactly what we would like to do so that you can see that, and then I'll hand it over to him.
Thank you.
Thank you, Chairman, members of the board. For the record, my name is Todd O'Connell, architect doing business at 1200 Veterans Highway, Hauppauge, New York. The reason for this garage is Kyrie has some beautiful cars, almost museum, which I'd actually like to hand up if you'd like to see them all to the board, because this is what this project's all about. So. So as you can see from the pictures that I've just submitted, these cars are, very expensive. They're very dear to her, and she wants to keep them at her home, close to her home. Space around the cars, to be able to mobilize around the cars is very important. So the garage was planned out from a space, where the cars didn't risk being damaged. And she can keep these cars in our home. Hence the size of the garage, where we had to go slightly larger than 750 feet, because we're looking to put 8 cars in this garage. All in these pictures, so they're just beautiful museum quality cars. The height of the garage is the main space in the garage is 12-foot ceilings, because we're going to have a storage ramp just to be able to put these cars on. And there will be attic space above it. The attic space above it, there's no stairs going up to it. It's only a 6.5-foot ceiling up there. It will have a pull-down stair, strictly so she can store items for the cars up in the attic, as opposed to around the perimeter of the garage itself. So it's strictly storage up there in the garage. Now, making the height of this garage 24 feet also does lend itself to some aesthetic character as it balances the home. The house is visible from the street and right next to the home, working a little bit more with the height of the garage helps balance the garage with the house itself, and we feel that would add some character to the surrounding neighborhood as well. Unfortunately, this property is sloped. We have some grading over here, but where we're putting the garage is an area where we're not interrupting the slope. We are within 10 feet of the slope, but we're not interrupting the slope itself. But no matter what we do on this property, because of the slopes that pre-exist, we have to be before this board. I believe that's true even if I was to build a garage on the opposite side of the property, because once you have a property that has these slopes, it's considered environmentally sensitive, and we'd have to be before the board. So obviously that's not something that we can change. We don't feel that this garage is going to have a negative impact on the character of the neighborhood. We don't feel it's going to have any a negative environmental impact. And we tried to make this garage as small as we could. We looked if there were other options. We've probably created a dozen plans back and forth trying to figure out what would work with these beautiful cars that you've seen here tonight. So that's what we're here before you tonight. And with that, I'd love to answer any questions the board may have.
My question would be, you're not requesting any setback variances, correct?
No.
This is going in the building envelope?
That is correct, and this is 60,000 square foot, the property, so we're only occupying not even 3% of the land with structure. So, it does feel like it's part of the house, because it's a very small division. It's, I think, only a 5-foot access way between the house and the garage. So we just feel it's, that's part of the reason we wanted to make it a little bit taller as well, so it kind of blended very nice with the home, and it is within the building envelope.
Did you consider maybe a breezeway?
To attach it to the house?
Mm-hmm. Because that takes away the height variance, doesn't it?
If I could just confer with my client for a moment?
Yeah. Between the house and the garage.
breezeway.
Perfect. And that, obviously, you know why, because that takes away the need for a height variance.
Yes, as long as there's no minimum, I'd have to talk to building, we're only looking for like a little 5-foot by 5-foot, roof over, not enclosed breezeway.
Correct.
And as long as the building, planning considers that
Is that right
attached.
to you?
So the code distinguishes between open breezeways and enclosed breezeways.
Okay.
I believe the enclosed breezeway is what considers it attached to the house.
She
If
does
it's
not want it.
open,
That
it's
wouldn't-
not.
yeah. And that wouldn't be possible to do it enclosed because that is the only way to the backyard between the garage and the house. So then that would not be an option.
Okay. All right, we'll discuss it. Thank you. Anyone on the board have any other questions? Planning.
Just one question. On the plan, it shows a set of stairways that comes out of the garage, I believe that's to the north, that's going into the sloped area.
Correct.
Why would you not put the stairs on the other side where there's no slopes? No, not that I can tell.
We don't need the staircase, but we need the walkway. So on that side of the house, because she wants to be able to access towards the driveway on that side of the house without having to go on the yard space and, and behind, through the gates into that back part of the yard. She wants to be able to get, God forbid, for safety reasons, a fire or something, that she could be able to get out on that side. We don't need the stair going to grade. It's really the walkway that's important to her.
It's not
Not
part
the
of the variance
staircase.
anyway, right?
No, but,
So it's
you
just
know,
a
it's,
design.
it's, yeah, design thing.
Yeah, but the stairs case is not important.
Sabrina, do you have anything?
I don't, thank you.
Anyone in the audience have any questions or concerns about this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion and a second, all in favor?
Aye.
Case closed. Thank you.
Thank you
Tom.
very much. Have a great evening, everyone.
You too.
The next case on the agenda, case number 19347, Deborah Baggielto. All right, I got it. 721 Meadow Road, Smithtown. The location of the property is the north side of Meadow Road, 868 feet west of Dilmont Drive. The property is zoned R21. The applicant is requesting variances to reduce the minimum side yard setback from 16 feet to 19 feet, to reduce the total side yard setback from 34 feet to 13 feet for an existing 90-square-foot deck.
Hi, my name is Deborah Bagelto, 721 Meadow Road, Smithtown, New York, 11787. The deck was there when I purchased the house back in 2013, and the house is set kind of crooked on the property. That's why I need to get the variance, because it's kind of close to the neighbor's fence. But where the deck is and where my house is way, way behind the two houses. That other two houses in front of me are all the way at the beginning of the road, and I'm all the way in the back. It affects nothing, does not affect, you can't even see the house from the street, so it's not affecting any, the way it looks or anything like that. And it's been there since I moved in, so I don't think anybody has a problem with that either.
Anyone have any questions on this application? No? Planning?
I just have a question. How did this become a problem?
I got a letter and said that it was out of compliance or whatever, and that's how this all started.
Nobody ever stopped by the house to take a look at it?
No,
or-
I think there was, when I purchased the house, it was a long time ago, but I think the real estate attorneys said that, oh, there's a an issue with your deck and I'm gonna take care of it. Never thought about it again. And just recently got a letter. Yeah, it was out of the blue. So
Okay.
I guess they said, ooh, you know, this is, you know, something that needs to be addressed or whatever. And, but I don't know, it just out of the blue came and I had to take care of it.
Okay, well, thank you.
Sabrina?
No, thank you.
Anyone in the audience like to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Motion and a second. All in favor?
Aye.
Case closed. Thank you.
Thank you.
He didn't show up, yeah. Okay. All right. The next case on the agenda is case number 19348, Michelle Majiri, 77 Laurel Drive, Smithtown. The location of the property, the east side of Laurel Drive, 155 feet north of Mowbray Lane. The property is zoned R21. The applicant is requesting variances to reduce the minimum side yard setback from 16 feet to 14 feet for a proposed 363 square foot two-story addition, to permit an accessory structure in the required side yard, and to reduce the minimum side yard setback from 16 feet to 4 feet for an existing pool, to reduce the total side yards from 34 feet to 18 feet for the proposed 363 square foot two-story addition and existing pool, to reduce the distance to lot line from 8 feet to 3 feet for the existing in-ground pool, to reduce the setback of a 2-foot retaining wall from the lot line from 2 feet to 0.
Good evening.
Hello. My name is Donald Mojeri. I reside at 77 Laurel Drive. Michelle's my wife. I'm going to defer to my architect, Ralph, that can speak on my behalf.
Thank you.
Hi, Ralph Michelle, 255 West Main Street, Smithtown, New York, 11787. The easiest part of this job is the side yard setback. It's two-story, yes, but it's a garage first floor, so it's an elevated ranch. So the first floor addition will really be the garage. What looks to be second floor is really just an extension of the one-story ranch coming across to make a larger living room. That's kind of the easy part. You can see, there you go, on the right side of the screen, there's the garage on the bottom part, and above it will be open, one large living space open to the existing family room as you come in the front door. A little bit more of the challenge is the pool in the backyard. The pool was permitted, it was inspected, everything went through. Apparently, when all the lines were pulled, they were pulled from the fence, which the fence is not on the property line, the fence is over the property line, which means that the pool filter is over the property line, and the pool is very close to the property line, and the retaining wall is over the property line. So when everyone from the pool company to the town came out, everyone approved everything. There's a CO on the pool. It got the final inspection, but now that we're going for no one would have known this even existed, except for now we're going for the addition on the house. So we can move the shed, that's pretty easy. Bit of a pain in the butt, but we can still have the pool filter taken off of the neighbor's property. The complication is we have 3.1 feet to the property line from the pool. They can take down part of the retaining wall over the property line and then just cut it at the property line.
So then the fence, the retaining wall, and the shed would all be brought back onto this property?
Right, yes, so we have to bring the fence. The fence would have to come onto their property line because, again, well, it's not on their property, it's on the neighbor's.
Right.
So,
That fence across the top is not my fence, that's the neighbor's fence.
Oh, okay, so,
but you have a fence around the pool?
The fence that comes this way in front of the pool,
That's your
that is
fence.
my fence. I had to enclose the pool as part of the permit to get the pool.
But the fence, see the line going left to right on the screen, your property line? That's their fence, but right on the property line, is there a fence that goes across right there? Right, see where the little hand is right there? Does that go left to right?
No, it goes just this way.
So see how, so your property line goes into their property line?
Correct.
So then, so how do we fix that?
Well, you would need, I believe, well, it is a requirement that he have a fence around the pool.
Code requirement that the pool has to
So
be.
you would have to have a fence on your property around your pool. So we can't grant relief onto the neighbor's property for your fence. So you would have to add a fence. Am I explaining it correctly?
Yes.
When I permitted for the pool, the company measured, I guess the assumption was, because I had an old, like the original survey, it didn't really have a dramatic drawing of where the property lines were. So everybody assumed that that fence was the property line. So when the pool was put in with the correct amount of distance from the fence, all I needed to do was enclose the pool. So I went straight across, and then there was an opening in the back, which I had to put a fence in, just to close the pool to make it compliant. So now I don't know what I would be able to do without keeping that fence there. Like I would have to put a fence in front of the fence, I guess.
Yeah, I think because it's New York State code that you have to have a fence around your pool, and we, as the Board of Zoning Appeals, can't grant you relief to put the fence on the other person's property to meet that requirement. You would have to be able to put a fence on that property line.
So I can't use his fence as an enclosure?
I think you can if you get a boundary line agreement or an easement, but, no?
Because then his fence would still be on the neighbor's property, so that doesn't solve the problem.
Right.
So, right.
If he does get an easement, can we put the fence on the easement? Not to the dramatic as much as that is, but you're gonna try to put a fence 3 feet from a pool, which is, that would be on the.
I think essentially what it would be is, I don't know how building's gonna look at it. You know, as far as we're concerned, it
Right.
It has to be on your property. I mean, I guess technically, if you had an easement to use that piece of the property, you put your own fence, that could be, but you know what I mean? Those are all kind of, you need to have, it has to be your fence and it has to be on your property or property that you have access, you know what I mean, that you have access to. So either way, you're gonna have to put your own fence.
Correct.
You can't use your neighbor's fence.
Right. Unless it was on the property line.
on the common property
Right.
line.
Yes.
So as a solution, I mean, that's a pretty large piece. If an easement, if they created an easement agreement that came just around the pool, so it kind of came up, over and back down, just to get around the pool area side, not as dramatic as what that is, then you, just for argument's sake, it came 5 feet up, 15, 20 feet across, 5 feet down, you know, you're talking a very small square footage of property you're taking from somebody else's, you know, if they agree to it, then you can put the fence on that property line and it'll box around the pool.
Yes, you can put your, and I think the thing is that you have to have the fence
And
because your neighbor can always take their fence down and then
Right,
it's not gonna,
yes.
suffice.
So it would have to go through an easement agreement between them and the neighbor.
Yes, that would be a private,
Correct.
And there is no request for any relief for the fence in this application anyway, so
Because
it
it's- yeah.
strictly is an agreement between them
Well,
and the
because
neighbor.
the fence is on the neighbor's property.
Right.
So,
if he's gonna put up another fence on his property that was, or an easement property, he'd probably have to come back.
Correct.
So, yeah, that's what I was just gonna ask. So let's just say the solution is put a fence on your property line, go away, right? And then he talks to the neighbor, and over the next X amount of months, they come up with some type of easement. The easement is then granted, and then he now has control of a small piece of property, and then he puts the fence on. Does he have to come back here again?
If it's a 4-foot fence, right?
Yeah, if it's above 4, right?
6 feet in the rear yard, though.
In that side, but that's side or rear? That's the side. Okay.
But
So
it's
we can have
behind the
6.
house, right? So it would be considered rear?
So we could put 6 foot,
yes.
but it actually wouldn't be your application, then it would be the neighbor's.
But just a quick comment, if you're planning on removing the shed,
Mm-hmm.
cutting back the retaining wall to at least the property line, you may even be able to cut it back say, a foot from the property line, you could just run a fence right along his property line, have the fence enclosed, and you're done. You don't need an easement agreement.
If you have brick pavers around the pool and just pop a safety net.
It has
in
to
it.
be, it has to be a fence.
It has to be
It's a fence,
yeah.
though. It's a mesh fence with poles in there. I mean,
I
you
don't-
could remove them and then put them back in.
I don't think those count as, they're safety guards for kids and maybe drunk adults, but, it doesn't count as state fencing, because it's not permanent. You can take them down. So, I mean, the big thing is now is put a fence 3 feet from the pool, and then see if they can come up with an agreement with their neighbor at some point later on. And then once that's done, the fence could, I mean, because I'm not even proposing that their neighbor has their own pool, so they have to keep their fence right now anyway. It's get the shed off, move the pool equipment, and then put the fence up on the property line. And then do the agreement, something much smaller than that kind of trapezoidal piece that's going up, just to go around the pool. Once they get that, then they can kind of reposition that fence around that area. And I don't think we even have to come back here, because then it'll be in their backyard, 6 feet high or 4 feet high, and it'll be okay.
So most likely, any approval from this board would have a condition that any structures that encroach on the neighbor's property are brought back onto your property.
Right, yes.
Okay.
Or enter into an easement agreement.
Well, for the sake of us, that's outside because they're not asking for anything.
They just
Okay.
would be able, unless it complies with the requirements, to say it's, as
We
long
won't
as it
complicate
complies
it.
with our requirements, then you don't have to come back. If there's something outside the requirement, then you have to come back.
Right, of course. And I think because, again, it's rear yard, and that easement would be for a rear yard, and 4 or 6 foot in the rear yard is fine anyway, we don't have to come back for any of that stuff. I think the temporary solution is get everything off, put the fence up, be in compliance, figure out what to do with the neighbor.
Okay.
And then the front yard, and then the piece in the front is kind of, we're asking for a very small variance for the front, for the 2-story addition. Typically granted as a normal side yard setback variance. That one's a little bit easier to manage.
Okay. Anyone on the board have any other questions? Planning?
That was it.
Sabrina?
Our comments were the encroachments, but we've addressed that.
Anyone in the audience like to be heard? Come on up.
Hello, my name is Frank McGarrigle. I'm at 73 Laurel Drive. Moved there in 1967. MC, capital G-A-R-R-I-G-A-L. And, yeah, I'm the neighbor with the extra pool equipment and the fence. But, yeah, it was always hard to tell just by looking where the lines were. So we understand if there was a misunderstanding or didn't realize where the actual property lines are. But now we know. And our concern is always about privacy. When my parents put the pool in the late 60s, and everything they ever did was always inside the building envelope. And my dad was very, adamant about making sure we don't need variances for anything and whatnot. Back then, you could see from property to property very easily. It was all open. Over the years, we've put in a lot of plantings, growth, and basically provide most of the foliage and property privacy. Looking at the situation now, we just learned by getting the notice that this actually was over the line, because we're not nosy. We don't look. And our fence has been there, and, it's a privacy fence. You can't see through it. And I guess when it was done, my parents were pretty old at the time. They weren't paying much attention to it. But anyhow, I look at this, and I think the solution, like some of it was coming out of the conversation, the neighbor to my north has a white privacy fence for his pool, and he put that in. If the same privacy fence was installed on the southern property line that ran to the back, that would provide not only just the privacy and sound reduction, would also let everyone know where the property line is going forward. So, the same 6-foot white type of solid fence, if that ran the property line, it really would matter to us what they did on the other side, right? But yeah, you know, the property's tapered, but you notice our property kind of tapers back, it's narrow in the back, so it gives us a lot less to work with. We probably would not look to want to sacrifice any more property. It would hurt our property value, I think, in the long run. We wouldn't really want to do that. So hopefully that input helps.
Yeah.
Do you guys have any questions for me?
I don't think so. Anyone? No?
Thank you.
Okay, thank you. Does want to come back up?
Hi again.
You want to address his concern there? I basically said the same thing.
It's basically, yeah, the same thing. It just sounds like there will really be no, unless there's some, you know, horse trading going on, the easement idea might not happen.
Yeah, and we don't, it's not subject of this application,
Right.
save for the fact that we have to approve what's requested.
Right.
To do that, we have to bring things back into compliance.
Everything we need to do to solve the problems for you guys and the property to bring into compliance can be done here.
Yep.
Anything else is a bonus.
Okay. Is that it?
That's it.
All right. Anyone else? No? Entertain a motion to close?
So moved.
Motion and a second. All in favor?
Aye.
Case closed. Thank you. There you go, Bill.
The next case on the agenda, case number 19349, Gregory Girardi, 47 Woodvale Avenue, Kings Park. The location of the property, the northeast corner of Woodvale Avenue and Cedar Place. The property is zoned R10. The applicant is requesting variances to reduce the minimum front yard setback from 40 feet to 28 feet, to reduce the minimum side yard setback from 12 feet to 0, to reduce the total side yard setback from 28 feet to 7 feet, for an existing 518 square foot side deck.
Good evening, Mr. Chairman, members of the board. My name is Vincent Tremarco. I represent the applicant. I have offices at 1040 West Jericho Turnpike, Smithtown, New York. We submitted the affidavits of posting and mailing to Mr. Donadio. The question that Blaze had with how come you got a letter, it seems that the new building, Chief Building Inspector Joe Loriface, is trying to clear up old matters. So my client, who applied for a variance in 2002 and was denied, for the next 23 years, nothing happened. The deck stayed there, and it's the same present state. So he gets a letter, he meaning Mr. Girardi, and he goes and sees Joe Loriface. And Joe looks at the situation and takes a position, and rightly so, Mr. Girardi is sitting right there, that this deck now, the deck needs to be there, and there is a ramp going up to the deck, and if you could look at the pictures before you, you can see that it was located basically right where the stairs were originally. And the reason for that is it was already set up structurally to hold up stairs, and now it's going to hold up a handicap ramp. The other issue that comes about is, well, I guess you could say, why don't we cut back the deck? Because there's, the ramp is really in the middle, and so we could cut down the side that's next to the, by the way, vacant piece of property next to our client. But, and I asked my client, what about that? And he said, well, there's a couple of things. One thing is that he doesn't wear the prosthesis all the time. The maximum he can wear it is about 3 hours a day. So more often than not, he's at home sitting in a chair with his wheelchair right next to him, and with the prosthesis not on his leg. So God forbid if there's an emergency and he has to get out, one way would be for him to kind of push himself into the wheelchair, roll out the side door. As you can see, there's a side door there, and then roll down the ramp. And that's, you know, if he was alone. The other situation would be, God forbid, there was a serious problem with Mr. Girardi, and they had to bring in a gurney. And you can picture a gurney, it's on wheels, it's probably 6 to 7 feet long. So the turning of the gurney and maneuvering it, if you look at the survey, it makes sense to have it, to have the access, ADA access stairway in the middle of the deck. You know, for those reasons, we feel that, first of all, it's not going to change the character of the neighborhood. The lot next door is vacant. Whether we can achieve the benefit by some other method, I guess we could cut the deck a little bit, but then if you do that, you're taking a chance that if in an emergency, whether it's Mr. Girardi or whether it's the emergency people coming, it makes it much harder to maneuver and make the turns. So we believe that the deck should stay the way it is. Actually, if you look at the denial that the new chief building inspector wrote up, you can see that he says it's for ADA accessibility. So he recognized that, and I think, you know, had the sense to tell Mr. Girardi, you got to come back to the board, but there's certainly a change of circumstances, a big change of circumstances. The area variance restrict, is it substantial? Well, yeah, it's substantial if you look at it from a normal situation. This is not a normal situation. We have a situation where we have a person that's obviously handicapped, and many times he's alone in the house, and if he has to get out, he can't be maneuvering his wheelchair in a tight area. So we think that in the normal situation, it would be substantial, but not in this situation. Will it have an adverse impact on the physical or environmental conditions in the neighborhood? I think not. It has nothing to do with the environment. Actually, federal law takes precedence over any environmental issue, which I don't think I'm going to have one tonight, but who knows? And then whether the alleged difficulty was self-created. Yeah, in the beginning, he built it. He shouldn't have built it. It turns out, because of his bad luck, some of the luck changed a little bit in the sense that he already had a deck there, and now, since he is disabled, it makes sense for this board to grant the variance, because he certainly didn't create the situation that he's in now. So we ask the board for its favorable consideration. I have Mr. Girardi here if you have any questions. Thank you.
All right. Anyone on the board have any questions?
No.
Planning?
No, thank you.
Sabrina?
No, thank you.
Anyone in the audience want to be heard on this application? There being none, I'll entertain a motion to close the hearing.
So moved.
Second?
Motion and a second. All in favor?
Aye.
Case closed. Thank you.
The next case on the agenda is case number 19340, Joseph and Lisa Vituli, 56 Sun Hill Road, Wisconsin. The location of the property is the west side of Sun Hill Road, 461 feet north of Lincoln Avenue. The property is zoned R15. The applicant is requesting a special exception to permit temporary living quarters, a variance of a special exception standard to increase the square footage of temporary living quarters from a maximum of 1,000 square feet to 1,140 square feet.
Good evening. My name is Joseph Vituli, 56 Sun Hill Road, Wisconsin, New York, 11767, Vitulli, and I give permission to Mr. Richard Pavone to speak on my behalf. Thank you.
Good evening.
Good evening, Chairman, members of the board. Richard M. Bavone, 308 East Meadow Avenue, East Meadow, appearing as the agent for the owners. Subject location, 56 Sun Hill Road, Wisconsin. You have a file that was created back in 1993 where the house was built with the parent-child, with the mother-daughter. Variance was approved prior to the permit even being issued for the construction of the house. My client purchased this house in 2004 with the intent of using the second kitchen, which they did, for his mother-in-law, and she used that area as it is today until she passed, which was about 14 years ago, and now it's being used by his daughter, so it gets continued use in the same way that it was approved back in 1993. Nothing has changed. Basically, we're transferring, even though it said non-transferable, to the new owner when the house closed, but actually with the building department and with the Board of Appeals, we have to transfer the paperwork, and nothing is changing as far as the character, as far as the existing conditions in the house, as far as the layout of the house is all the same. The increase of 140 square feet, again, was also approved back in 1993. So that's 32 years of the same exact use, and also with a second kitchen. So the existing conditions that they are today were as they were when they were built and CO'd with the house back in the 90s. There's no adverse impact to this property, the surrounding properties. There's no environmental issue. He went around to his neighbors, and actually, besides the regular mailings that we had to do, was your requirement, but he also received letters, signatures, which I submitted to the board. It's in our packet. 51 Sun Hill Road, 52 Sun Hill Road, 54 Sun Hill Road, 55 Sun Hill Road, 57 Sun Hill Road, and 59 Sun Hill Road, stating that those neighbors have no objection to the existing conditions continuing its special exception for a second kitchen, and also for the increase of the 140 square feet, again, which was approved by the Board of Appeals. When the use ceases to exist, the footprint of the house will remain the same. However, the kitchen can be removed, and it's still going to be a one-family house, and the character of the neighborhood is not being changed. That is it.
Okay. And I believe planning prepared a PAR.
We did.
Care to elaborate?
Of course. So we reviewed the application. As was stated on the record, the temporary living quarters was originally approved in January of 1994. It's been in existence for 31, 32 years. The layout has not changed. It's being utilized as a special exception for an immediate family member. Therefore, we recommended approval.
All right. You okay with that?
That would be fine, and thank you.
Sabrina?
No comments, thank you.
Anyone on the board have anything? Anyone in the audience like to be heard on this? All right, there being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion is second, all in favor?
Aye.
All right, case closed.
Thank you, and have a wonderful evening. Take care.
send one to Simone. I'll send one over to
You know, if it's uncomfortable to stand, you can sit down and just address the board.
I don't, how would that work? with
That
the-
comes off.
You can take it with you.
That's okay?
That's no problem.
Want to read us in?
Sure. The next case on the agenda, case number 19341, Myra Properties, LLC, 555 Wireless Boulevard, Hauppauge. The location of the property, the southwest corner of Wireless Boulevard and Adams Avenue. The property is zoned LI. The applicant is requesting variances to increase the maximum gross floor area of the lot from 42% to 63% for a proposed 15,780 square foot first floor addition, 42,845 square foot second floor addition, and 17,100 square foot third floor addition. To reduce the minimum landscaped area in the required front yard from 80% to 65%, to reduce the minimum parking setback on Wireless Boulevard from 50 feet to 31 feet, to reduce the minimum parking setback on Adams Avenue from 50 feet to 29 feet, to reduce the length of truck loading spaces adjacent to loading docks from 65 feet to 42 feet, to eliminate the required landscape islands.
All right, good evening.
Good evening. Thank you for the accommodation. I had knee surgery last week, so I do truly appreciate it. My name is Allison Lapointe. I'm with the law firm Sir Tillman Bowen Adler Hyman with offices at 100 Motor Parkway, Hauppauge, New York, 11788, and I'm here on behalf of the applicant. For the record, we have submitted all of our notice documents to the dais, as well as 8 resolutions from prior approvals by this body, floor plans and elevations by OMLK Architects, landscape plans by FPA Associates, as well as a prior approval for this property just last August, which we will explain why we're back. So we were previously before this board on August 7th, 2024, and we were approved for a height variance as well as parking relief. Since said approvals, the scope of the project has changed. The applicant is seeking to move their production from Asia to Hauppauge, and this would be first of its kind high-tech manufacturing jobs right here in our community. As such, the scope of the project changed. All previous relief from this board has been abandoned. The previous site plan that was submitted has been withdrawn, and the new relief we're seeking is now before you this evening. So overall, the site is 5.35 acres. It's zoned light industrial and is located on the corner of Wireless and Adams in the heart of the Hauppauge Industrial Park. The existing structure is 69,874 square feet, and we're surrounded to the east, northwest by light industrial, and then to the south with a zoning out parcel, which is commercial. This lot is a few blocks north of Motor Parkway. So the property owner will be an owner-occupied, different entities, but owner-occupied building. Orbic develops and manufactures smart technology, including smartphones, tablets, computers, and wireless tech. Those are all provided developed with access through Verizon. If you go on the Verizon website right now, you can buy Orbic products. The property owner is seeking to transition their production out of Asia and bring these high-tech manufacturing jobs to the town of Smithtown. We're talking about approximately 500 high-tech jobs that would be operating on multiple shifts. This project has enthusiastic support from the town as well as the county and the state, and Verizon is also fully in favor of moving this production stateside. These are exactly the kinds of jobs that we, as Long Islanders, have been trying to fight to get into our backyard. The applicant has worked exhaustively with the civil design team as well as industry experts to create a plan and layout that will provide exactly what they need to begin production. So what the applicant is proposing is to construct a height-compliant 3-story addition on the south side of the building. The first story would account for 15,780 square feet, and as you can see from the floor plans I've submitted, would house a loading area, a commercial kitchen, full cafeteria, locker rooms, restrooms, security, and airlock. So that first floor of the addition really is more of a support area. It has nothing to do with the direct production, but all staff will enter through that side. They will be able to put their things into the locker room, then go through the airlock to remove any contaminants because it's such very sensitive technology that they're producing that once they're in the building, they won't be leaving the building again to the end of the shift, which is the reasoning for having the full service cafeteria on site. Because the more times people are entering and exiting the building, the more likely you'll have contamination, which could then lead to issues with the production line. The second floor of the addition is 17,100 square feet, and this would contain an assembly area. And the third floor of that addition is 17,100 square feet, which is warehouse and storage. There is also a proposed second-story addition over a portion of the existing building, which will also be storage and warehouse. That is 24,500 square feet. So the breakout of the uses, I think, is important, particularly when we're talking about our gross floor area. Of the additional space, 41,500 will be warehouse, 15,000 and change will be accessory support areas for staff. So it's not going to be increasing the number of bodies, the number of trips on the site, the intensity of the use of the site, but really it's accessory use for those who are already operating on the site. Only 18,000 square feet is proposed for new functional production space. So other site changes that are going to be proposed as well, which are part of the site plan application, which has been submitted to the planning department. We're expanding the parking lot to make sure that the site is parking compliant, upgrading the drainage. There's a proposed new vegetated berm along Adams and Wireless, which you can see on the landscape plan I submitted, upgraded and modernized facade, as well as new lighting and other improvements. So as Blaise so kindly went through, there are a number of kinds of relief before you today. The first one I'd like to discuss is the parking setback. In your packet, there are 8 prior approvals of similar or greater setback relief for parking areas within the Hauppauge Industrial Corridor. Right now, there is an existing row of parking along the landscaped side of the property, but there's no parking along the building side. The applicant is proposing installing new parking along the building side and pushing the existing parking closer to the roadway. Most of the existing vegetation will be removed. It's not the most robust vegetation at this time, but again, the applicant is proposing a fully vegetated berm. The berm will be 5 feet in height from the roadbed and 4 feet in height from the parking lot grade. So it should do an excellent job in screening the additional parking on the site. In terms of nature and character, again, I have submitted 8 prior approvals, which show that not only is it relatively common in this corridor, but also that it has past approvals of this body. And because of the review of the existing development patterns, I say that there'd be no negative impact to the nature and character of the community if granted. In terms of substantiality, while numerically it might be considered substantial due to its great conformity with the community, I would say that overall it's not a substantial request. And in terms of feasible alternatives, we did look at a number of feasible alternatives, even as so far as to look at neighboring properties and consider putting in a parking garage. But between cost and then the pedestrian concern of people scooting across Adams to get to work back and forth, that plan was abandoned. And this is the most feasible alternative to make sure that this is a parking compliant site. Next would be the relief for the minimum landscaping in the front yard. With the additional new parking, of course, we're going to be reducing the landscaping. Again, 5 resolutions have been submitted that show similar reductions or greater reductions within the corridor. And again, because the existing vegetation is not that excellent, we believe that it will visually look like a greater vegetated buffer because rather than just being grass and sparse trees, we'll have a densely vegetated berm for screening. In terms of substantiality, I put forth that it's neither a numerical or a functional substantial request. And again, because of the parking needs, there were no feasible alternatives. The third bit of relief we're seeking is for the gross floor area. So the applicant is seeking to increase the gross floor area to 63%, where 42% is permitted. As previously described, the applicant is proposing the 3-story addition on the south side of the building and a 2nd-story warehouse addition over an existing portion. As I stated, the vast majority of this addition will house warehouse and storage and support areas. Again, the cafeteria, the locker rooms. Only about 18,000 square feet will be utilized for production space. So one of the main reasons gross floor area is regulated is to ensure that you have enough support in the area. You don't put too many cars on the road, you don't require too much energy, you don't have to require too much sanitary. As the vast majority of our overage, actually I believe the entirety of the overage of our gross floor area is passive space, I put forth that there will be no negative impacts because of that. So again, the active space, the production space on the site can be contained within the 42%. But over that, it's really the storage area for the materials that are needed for the production, that puts us over. In terms of substantiality, that again, I'd say that it's not functionally substantial because there are no negative impacts that are anticipated, while I certainly could respect that one would consider it a numerically substantial request. In terms of nature and character, gross floor area is also used to control the visual scale of a building. Now, as gross floor area is the measurement of each of the individual floors against the overall square footage of the property, I put forth that there are a number of buildings that are within the 50-foot height that maintain similar footprints in the neighborhood. What is not visible from the roadway is whether or not it's a single story with just an open scale for storage, or if there are multiple floors in there. Therefore, I put forth that it will not be indiscernible as to whether or not there'll be a change in the nature and character of the community, because gross floor area is not something, unless you're just talking about one large building that has the footprint that is also incredibly large. Visually speaking, there'll be no negative impacts because you can't tell from the exterior of the building how many floors will be present. And again, in terms of feasible alternatives, all possible alternatives were considered. This team worked extensively both with the professional team who designs and puts the layouts together, and you can see from this level of detail that we have in the floor plans, every inch of this building has been maximized to make sure that the relief before you is the least we require in order to function and establish this use here in Hauppauge. And this was the smallest relief we could seek to be able to move forward. The next bit of relief is the length of truck loading spaces. Applicant requests 42 feet where 65 feet is required. In speaking with the applicant and their production team, they do not accept deliveries from tractor trailers. The type of the type of production we have here, it's not like if you were doing production of paper goods where you require reams and reams of paper, bulk deliveries coming from single source. Because of the very specifics of this technology, you get multiple smaller deliveries from multiple sources because the complexity of what is being developed here. So because of that, the applicant feels strongly that they'll be able to operate quite well and without any interruption with a 42-foot loading area. And then the final relief sought are the landscaped islands, I apologize. I've submitted for your consideration 5 resolutions of past approvals that have granted same and similar relief. We expect no negative impacts from the community, and again, it will not be visible from the street due to the berm. So with that, the owner has been working collaboratively with the town to bring these high-tech manufacturing jobs into our community. They have the enthusiastic support of both the town, the county, the state, and Verizon to move forward. And we respectfully request that the relief sought is granted, and I am available for any questions.
All right. I just have one thing. Obviously, Very nice plan. It's obvious a lot of work went into it. Thank you for that. The landscape, one of the things we do with the industrial park, because it is very important to the town of Smithtown, and we try to maintain its character. One of the things that is consistent on a lot of the previous approvals, when we do reduce that setback and that buffer distance, we try to increase the density, which is what you've done in your plan, which is certainly appreciated. I think one of the things that may, at least for me, would be to, basically put it in as a condition that it would be planted and maintained, so that a subsequent owner may, want to say, oh, let's just take that out. Obviously, if there's nothing in there to prevent that from happening,
That's
would be an issue.
perfectly reasonable, yes.
Okay, and that was the only thing that I had. Anyone else have anything? Planning?
Thank you.
Sabrina?
No, thank you.
All right. Anyone in the audience like to be heard on this one? Anyone? There being none, I'll entertain a motion to close the hearing.
So moved.
Second.
Motion and a second, all in favor?
Aye.
All right, case is closed. Thank you.
Thank you, have a great evening.
You too.
When did you have your knee surgery?
It was last week.
You're doing well.
Well, good luck. I believe that's it for our open cases. Case 19299, Lauren Gurin.
Case 19299. I'll make a motion to approve the application as presented.
Motion and a second, all in favor?
Aye.
Motion carries 5-0. Case 19332, Jacob Levy and Carolyn Colella, no action. We're going to hear that one on July 15th. Case 19335, Pasquale and Megan Iannucci.
On case 19335, I'll make a motion to approve the application as presented.
Second.
Motion and a second, all in favor?
Aye.
Motion carries 5-0. Next case is case 19336, Louis A. Forisi.
So on case 19336,
Oh, I had a question, actually.
Yeah.
If you want to discuss it.
The one that we needed to wait for highways?
Yeah, I don't know that we
Yes.
need to wait for highways, because you said it yourself, there is no maximum curb cut. So why are they asking the board for
There
variance
is
for-
no specific maximum curb cut width for a residential curb cut listed in the zoning ordinance. There are standards for commercial curb cuts, which this is even exceeding a commercial curb cut width.
Right.
So I think it would probably be beneficial for the board to get some kind of response from the highway department, one way or the other, whether they're okay with it or not.
Well, because I was just going to say, why would we touch the curb cut?
I don't know.
As a-
It
as
may
the Board of
require
Zoning
a
Appeals.
permit, so if they don't comply with whatever they're gonna, you know, understand what I'm saying? If they want something specific highways, it probably would be good to know that before
Okay, so.
we grant it, yeah.
Okay, so why don't we request from highway?
Comments?
Yeah.
My understanding is that curb cuts, are very dicey.
And that's a very excessive width. I have a rather large, wide driveway, and my curb cut's about 15 feet wide.
So could we, instead of saying what are they okay with, can we ask them what a standard curb cut for 2 cars is?
Yeah.
And then that's what our approval could be based on? Because obviously he said he wanted to be able to get 2 cars out of the driveway.
Right.
We can
Without-
deal with the pavement once he's inside the property.
Right.
But the curb cut is kind of their domain.
Yeah.
So does that make sense?
Yep.
So we will leave this one open till next,
So no action?
no action. Thank you. All right, so. Case 19337, Gary Shank has been adjourned to August 12th. Case 19338 has been adjourned to get clarification from building. So we'll we would just have to close it
Um,
once they give us that info?
So, yeah, once we have the information, assuming that the information you already have is correct, or
If there's an additional
If there's an
variance needed.
additional variance or if it changes, but as long as you have what you need, you can close it and then make a decision, but we have to make sure we're talking about the right location.
So are you doing this on August 12th?
Why don't you just continue it until
Yeah,
August 12th?
yeah, I thought we had it written on an 8/12 meeting.
At
plus
the August 12th
12th
meeting, we would basically decide it, assuming,
Right, but they would have to have. the
if they have an
power to
additional
determine.
variance, they're not going
Right.
to make August 12th, right?
Well, they could advertise it and they could be there on the agenda.
Okay, so we'll just wait and we'll decide it.
So we'll call it adjourned till August 12th?
Yeah.
Okay.
Case 19339, Danielle Cicciolini. We have no secret, correct?
Correct. Yeah, that's right. Yep.
So no action on that one. Case 19342, Michael and Laura Kern. I believe we're waiting on secra for that one as well.
We were holding that open for something?
He's going to give us revised plans to.
Correct.
Right, to
Sabrina.
eliminate one bedroom?
All right. Case 19343, Anthony Robitaille.
Okay. On case 19343, I'll make a motion to approve this application as presented.
Second?
Motion is second, all in favor?
Aye.
All right, motion carries 5-0. Case 19344, Anthony Monterosso.
On case 19344, I'll make a motion to approve the application as presented.
Second?
Motion and a second, all in favor?
Aye.
Aye.
Motion carries 5-0. Case 19346, Barry Larson.
So, on this one, let me ask you, they don't need the variance for the accessory structure, am I correct?
No, they would,
Fine.
because the breezeway did not work.
Correct, it's not attached.
Oh, it didn't work?
Right.
She wants it to be open.
And, obviously, I don't have to say this, but just as a FYI on the record, the board has not approved a detached structure at this height for anything that's come before it. So 24 feet is excessive. I understand what it is that they're using it for. I appreciate it, as somebody who appreciates classic cars. But 24 feet is excessive. Perhaps they could lower the height of the roof by eliminating the storage space on the upper floor. And that way they could bring down the height of the structure maybe to 20 feet, 19 feet.
Talk to them, or do you want to?
If that's what the board wants, if you want us to reach out to the applicant and let them know what the board's thoughts are.
I would say maybe ask them if there is a design modification that could, shave a couple feet off of it. This is somewhat of a unique application, of the lot is significantly larger than most lots. There are no setback variances, so I can certainly personally be okay with a little more relief than usual, but, obviously if we can grant the minimum relief necessary, that would be better.
So no
So
action.
no action. This back is growing.
I see that. And it's not your fault, Sabrina.
That's right. For
That's
the
right.
record, it's not my fault.
Case 19347, Deborah Baglietto.
On case 19347, I'll make a motion to approve this application as presented.
I believe Sabrina had
I had a
comments.
couple comments, but it was regarding
What?
encroachments on the western property line. It's not part of the application. We were just bringing it to your attention, but there was a retaining wall and some fencing that encroached along the western property line.
On a neighboring property?
Neighboring, what did I say? Yes, neighboring residential.
All right, want to make a motion?
I did. But
Oh, sorry, well, I didn't hear a second. We have a motion and a second. All in favor?
Aye.
All right, motion carries 5-0. All right. Case 19348, Michelle Morgari.
Okay, on case 19348, I'll make a motion to approve this application as presented with the condition that all structures are being bought back on the applicant's property.
Okay,
Second.
motion and a second, all in favor?
Aye.
All right, motion carries 5-0. Case 19349, Gregory Girardi.
On case 19349, I'll make a motion to approve this application as presented.
Second.
Motion and a second, all in favor?
Aye.
Motion carries 5-0. Case 19340, Joseph and Lisa Vituli.
On case
We
19340.
have, I think we have
I have a
comments.
comment just for the record. Our seeker is based on our understanding that there are no additional bedrooms currently being added to an existing two-bedroom temporary living quarters within the existing two-bedroom single-family dwelling. Otherwise, an increase in the number of bedrooms would require a referral to the Department of Health.
Okay, that's just for the record, we don't need that.
Correct, for the record.
So just approve it.
Yeah,
On case 19340, I make a motion to approve the application as presented.
Second.
motion and a second, all in favor?
Aye.
Motion carries 5-0. All right, case 19341, Myra Properties LLC, we need a secra.
On case 19341, I'll make a motion to approve the secret.
Second.
A motion and a
On
second,
the
all in
merits.
favor?
Aye.
All right, now on the merits.
On the merits, on 19341, I'll make a motion to approve the application as presented.
Can we add a condition that their-
Planting is and
that the
maintenance.
berm and buffer be planted and maintained?
So we can do a condition that basically says, the applicant shall plant and maintain buffers, planted buffers along both rights of way, as approved by the Board of Site Plan Review.
Perfect.
There you go.
All right, second?
Second.
Okay, motion and second, all in favor?
Aye.
All right, motion carries, approved with conditions, 5-0. Good meets, 19345 is adjourned to August 12th.
Oh, wow. What about August 12th?
And I believe we have from 1022,
Yeah.
case 19208. That's Marquette.
John, when did you started in this year, right?
Do you need to know when
Both
the
of you
date was
started this year?
originally for this?
Yeah.
Okay, so neither of you can vote on this one. It's fine,
Yeah.
there's enough.
Correct. Now, that was case 19208.
But I was here in spirit, if you need.
As always, John.
Okay, I have my notes. I had that it was a very unique lot. I believe that the setback being requested was only in one corner. of
Yes,
the-
it was. That's what my notes said.
Okay. Secret's a type 2 with comments, Sabrina?
Yep. Our seeker is based on understanding that there are no additional bedrooms currently being added to the existing four-bedroom, single-family dwelling, no bedrooms in the basement, and no accessory apartment in the detached garage. Otherwise, an increase in the number of bedrooms would require approval from the Department of Health.
All right. So that, only Adrian, myself, and Bill can vote on this
Okay.
one, right? So we need a motion.
Okay, on case 19208, I'll make a motion to approve the application as presented.
Second.
Motion is second, all in favor?
Aye.
Aye.
Okay, motion carries 3-0. All right, we have a request for an extension.
There's only three of us can do this, right?
No, we all can, right?
Alaska is just the request, right?
Yes.
Yeah, well, you can vote on that.
So when we're requesting an extension, the entire board can vote,
Yes.
correct?
Okay.
It's just based on the information that we're letting you
Yes.
Okay. Okay, in case 18990, I'll make a motion to approve the extension.
All right,
Second.
motion and a second, all in favor?
Aye.
All right, 6 months to 9/26/25 granted. Is that all we have?
That is it.